Welcome to Shielded, the podcast dedicated to helping Florida's first responders understand the laws that affect their work and their lives. We bring clear answers, practical tips, and stories to help you when you need it most. If you're a first responder in Florida, this is your playbook. Be sure to check out all of our resources at bicklerlaw.com. I'm your host, Paolo Longo, and I'm here with my partner, Jeff Bickler. At Bickler & Longo, this is what we do. Now let's get into it. Today, we're going to be talking all things Hart Bill related. What is it? Who qualifies? And how do I get it? So we're going to jump right in. We're going to give you the four elements of the presumption, and then we're going to break each one down. But before we get into the elements, Jeff, why don't you give us a little bit of history on the Hart Bill? You know, why do we have it? Who it's for, and what's the reason behind it?
Yeah, I think it's always a great idea to give people some context and some background about this legislation because it tends to be confusing, but it all originated actually back in the late 50s and 60s in fire service. They recognized that there was an increased risk of cardiovascular failure, particularly on fire scenes. And so that led to a lot of research and also some presumptive legislations, primarily in pro-labor states early on, to recognize cardiovascular disease for firefighters. And so that was sort of the genesis of it. And then it moved around the country. And then we got our first Florida firefighter Hart Bill presumption in the 60s, actually, as well. And, you know, that continued to be the case in fire service where we had hypertension and heart disease covered, you know, for decades. And then finally, in the late 90s, the law enforcement lobby started to get active on the issue. And they passed the very first presumptive legislation for police officers. And the first provision that passed was for state law enforcement, and that was in 1999, I believe. Yeah, it was 1999. And then what happened was we litigated the meaning of state law enforcement officer for about 2 years, believe it or not. Who does that actually cover? And then in the first legislative session after 9/11, the 2002 legislative session, they clarified what they intended, which was all law enforcement and corrections officers. So since that time, since 2002, our Hart Bill has covered not just firefighters, but all of our law enforcement officers, municipal, state, county, corrections officers, anybody who's a certified law enforcement officer has coverage under the existing legislation.
Right. And so to be clear, right, the Hart Bill is for police, fire, corrections. No matter if you're a state law enforcement officer, a county deputy, a municipal police officer, we're good. Now, there's a caveat to that, right? Because one of the four elements is you have to be a member of the protected class. What about our auxiliary police officers and our volunteer firefighters?
Well, that's tricky because you have to be professionally affiliated, right? So you have to be employed as a full-time professional firefighter. The same thing is true in law enforcement in order for you to have coverage. And we do get those questions frequently. I feel as though the volunteers should certainly be covered as well, but it's just not the way the law is currently written, and maybe it should be addressed legislatively.
Well, that's something to definitely keep on the radar because we do get our share of phone calls, especially from auxiliary officers and volunteer firefighters who, aren't going to be able to avail themselves of the presumption. So right. getting into the elements, right? So there's four elements that we need there's four boxes that we've got to check, right? You've got to be one, a member of the protected class, which is police, fire, corrections, full time. You've got to have a clean pre-employment when you started, with your agency. You've got to have a covered condition, right? And we'll get into that in a minute too. And then the last thing you have to have, which is real tricky, which carriers like to fight, is the disability element, meaning the condition's got to prevent you from working. So we talked a little bit about who's covered and who's not, right? So you got to be full-time. Auxiliary and volunteers, don't get the coverage. So the next box is pre-employment physical, but pre-employment physical, that's a big umbrella, right? What are they talking about when they're saying you have to have a clean pre-employment physical?
Yeah, that would seem to be a pretty straightforward issue, but, it tends not to be like so many of these elements. Yeah, the clean pre-employment physical simply means that when you entered service with the employer that you're making the claim against, and that's how the statute has been interpreted, you didn't have the condition that you're claiming. So if it were hypertension as an example, when you started service for the agency that you're making the claim against, you didn't have hypertension at that time, or there was no indication on the pre-employment physical that you had hypertension. Same thing would be true of heart disease. Now, some employers and carriers have read that, or tried to read that statutory language as one excluding all. So, in other words, if you had hypertension on the pre-employment physical, you couldn't make a claim for heart disease. Well, that's been clarified by our appellate courts, and that's not the case. You could have existing hypertension on a pre-employment physical and still make a later claim for heart disease. But yeah, just in terms of what it means, it's simply that you had this physical at the time you entered into employment. Importantly, with the employer you're making the claim against, right? Because we have a lot of firefighters and law enforcement officers that will go from one agency to the next, and then they may leave one agency with hypertension, start with a new agency, and show up with the hypertension, and then try to make a claim, and that becomes extremely problematic for obvious reasons.
Right, right. And a lot of things that what we see, being challenged on this pre-employment issue is, well, first is they can't find it, they lost it.
Right.
The pre-employment physical committed suicide by jumping into a shredder. There was a flood.
Convenient.
There was a flood. There was a flood, and that drawer got destroyed, and so there's no pre-employment physical. And the other thing we see is when somebody, and this is more, I think, on the law enforcement side, they start out, they go to police academy, they get certified, but they're not working yet. They're maybe starting at part-time or in an auxiliary status as an auxiliary officer. And then 6 or 8 months later, they come in full-time, right? So the pre-employment wasn't really at the time they became full-time. It was when maybe they went to fire school or they went to police academy. So we see that a lot too. How do we deal with some of those problems?
Yeah, and that's just such a really difficult and unfortunate situation that we do see happen. The courts have been kind of loosey-goosey on this notion of entering into service. Like, what exactly does that mean? And we don't have a clear definition on this. Our assessment of it was if the pre-employment physical occurred, even in the first year, prior to full-time employment, that should be sufficient. But unfortunately, our judges of compensation claims have been more restrictive, and our appellate courts have really not addressed the issue head on. So, yeah, I mean, that's an issue that I think, again, should be probably addressed legislatively. If there's a question, however, I mean, we're always going to err on the side of trying to pursue the benefit on behalf of the officer or the
Right.
firefighter, whatever it may be.
Right. We've had a couple of these cases come down the pipe, over the years. And there was a case we had where the pre-employment physical was within 3 months of hire,
Right,
and that was found to be, sufficient. Then you have another case where the full-time employment didn't start until 20 months
right.
post physical, and the judge said, well, that's not immediate. 20 months is too long. So therein lies the problem, right? Somewhere between 3 and 20 months, that's just too big of a gap, I think. And so obviously, legislatively, but I think the message that we need to get to our clients is get a copy of your pre-employment physical, right? Even if you don't have a problem
100%.
now, if you don't have a problem, even if everything is okay, you're young, there's no issues, just go down to your HR, get a copy of your pre-employment physical, keep it in your safe at home, because you never know, in 5 or 10 or 20 years, something is going to happen and you're going to need a copy of that thing. And all of a sudden,
And they won't be able to find it. Yep.
and they won't be able to find it, right? There's going to be a hurricane or a flood or somebody dropped a shredder on top of your physical, because without it, there's no case, right? I mean, that is a hard conversation to have with somebody
Yeah.
who would spend a lifetime, a career's worth of time serving, being a public servant, coming down, ending up with one of these covered conditions. And you got to tell them, well, there's no physical. We
Right.
can't prove that you didn't have this condition when you started. therefore there's no claim. I mean,
I,
that is a tough conversation.
it's a horrible conversation. I would say this, Paolo, and we've had those cases, obviously. I mean, they're almost legendary in our firm because of the crazy excuses that we get about this stuff, right? And we've heard everything possible, including hurricane and floods and fires and all kinds of nonsense, right? But we have taken a position as a firm that if that employment physical is lost, we're still going to go, as long as it's the employer's responsibility to retain that document. We're
Right.
always going to take that case because, as a record custodian, they have a fiduciary obligation to maintain that record. And if they haven't done it, we believe there's a legal inference to be drawn against the employer, that the physical not only was there, but that it was fine. And yeah, it gets a little trickier in those cases, but those cases still are worth pursuing, as long as there was a physical. I mean, that's really the key, I guess.
Right. I mean, we're not afraid to take those cases, and we're certainly going to litigate them. But you can save yourself a whole lot of headache
100%
by
correct.
just getting a copy of your
That's
physical.
physical.
Just
I mean,
get a copy of it, scan it, put it in your safe, put it in your safe to deposit
yeah.
box,
I mean,
and
you've talked to these even young recruits and guys who are just starting out their careers. We always tell them, get that physical and put it in your file,
right.
just for future safekeeping.
And an interesting point legislatively, right? The legislature changed this rule regarding firefighters, right?
Yep. Yeah, yeah.
Okay. And
And yeah,
so,
there we're back to who's got the better lobbyists, right? I mean, it's crazy.
right. Well, that's another podcast, right? But that's another episode. There's some truth in that, okay? Because, the legislature recently amended the statute for firefighters that even if they can't find it, then it's presumed to be clean.
It's presumed clean, and yeah, so all the benefits that would flow as a result of that will flow.
Right.
As long as the other elements are met. But
Right.
and that's the crazy thing about this, Paolo, right? When I started doing this work, way back, in ancient times, they didn't fight heart claims by and large. So I was working with Dick Sicking in Dade County. I mean, a guy would get hypertension, they would just pick the claim up and pay it.
Right. But 30 years later, they're still paying that claim. And they're like, and now they're all of a sudden they're saying, well, hold on a minute. We got to
Yeah.
figure out what's going on. Are we going to pay these claims until, the cows come home?
Well, I think the point I'm trying to make is, all of the focus on these elements that, because that's what our burden is, right? And the employer knows, and, as soon as that presumption applies, they're likely to lose the case. So the only way that they can really beat a claim like this is by trying to beat us on the elements. So that's why we've seen all this litigation over the years, whether it's about pre-employment physicals or disability, which has become such a crazy morass and, of difficulty just because of, how hotly it's been litigated. That's really where the game is played on the defense side, is try to find an element that we can't meet somehow, and then defeat the claim that way. So the presumption doesn't apply, and then, it's our burden and we can't meet it.
Right. That's always the best way for an employer to beat a claim is to kill the presumption, because once the presumption is met, you're exactly right. I mean, it's very hard to overcome. So they're going to try and take our legs out at the beginning. That's why it's important for folks for this podcast, check out the website, read the blogs, call us, ask questions, make sure that we can do everything possible to make sure that these first 4 boxes are checked, because once those boxes are checked, it's an uphill battle for the employer. But
Right.
if they can uncheck one of these boxes, then your case is essentially dead before it starts, right? So that's why it's important to talk to us early in these things, because once we can establish the presumption and we can check those 4 boxes, it makes your life a whole lot easier. So that's why when we're talking about pre-employment physicals, get a copy of yours, because you may never need it, but that one time you need it, boy, it could be a lifesaver.
100% agree with that.
So moving on to number 3, right? Number 3 is cover condition, right? And like you said, we never used to fight over cover condition, right? I
No.
mean, somebody had hypertension, they got a stent, they had a heart attack, they got a pacemaker. I mean, it was automatic, right?
Right.
But in the past couple of years, wow, they're dissecting everything. Is this heart disease? Is this hypertension? Does this count? Is this really medically necessary? And so this is just one more area where they're trying to cut our legs out early. And so it's important, at the beginning of your claim to get your condition documented, to seek medical care, to really see the appropriate doctors and get this stuff lined up, because there could be an attack on, well, what you have isn't even a covered condition, right?
Right.
We've had some cases come out lately there that the judges are like, well, that's not even heart disease, right?
Well, I mean, Paulo, I just had one today. I mean, literally, and this happens so frequently, right? I mean, it didn't even think about it when I was talking to the client this morning, but it, the guy goes in for a cath procedure. He's got chest pain, cath procedure, and he's got coronary artery disease, but it's not sufficient enough for intervention, like either a stent or a bypass procedure. And so the argument then is that it's not a covered condition, right? And so they deny the claim. Well, of course it's heart disease. There's no question. The fact that it may not be sufficient enough to stent the blockage doesn't mean there is not blockage. It doesn't mean there's not heart disease, right?
Right, right. So essentially what they're saying is that he's fortunate enough to not need a bypass. They caught it in time. So he doesn't have the condition because
Right.
it didn't rise to the level of him having open heart surgery, which is complete nonsense.
It wasn't severe enough. I mean, it literally then, and that's just kind of a crazy reality of what we're dealing with now.
Right. So they're essentially expecting our clients to go get a heart surgery or have a heart attack first, which is just asinine in and of itself. It's
Well,
ridiculous.
and not what was ever intended with the law, and also against public policy, which is, and this kind of we can get into this some more on the disability discussion as well. But what you want here is to recognize the conditions and treat them early, so that you don't have more difficult or disabling outcomes. The ideally you're going to treat these conditions and keep your first responders healthy. But instead we play these games, and we're going to try to say, well, it's not a covered condition, it's not severe enough, there's no disability, all this nonsense to avoid coverage. And then the person just ends up getting worse and worse over time, and you end up with maybe a career ending condition, right?
Right. And then they're paying all kinds of stuff after that, when they could essentially just accept the claim early, pay for one medicine, and get the guy back to work and let him finish his career.
Yep. I mean, I honestly just have never understood that kind of defensive approach, but it's what we see across the board.
Well, they're going to get a taste of us shortly on that case.
Yeah, I know you can't wait to get busy on that one.
Yeah, that'll be a good one. And so that's a good segue into our last element, which is, you mentioned earlier, disability, right? This is an element that we really do fight over. A lot of the conditions. I mean, obviously, if you have a heart attack or you get a pacemaker or you have bypass, but those are big procedures, those are big conditions, and you're going to miss time from work, right? And the word disability doesn't mean that you're disabled. It just means that the condition has prevented you from being able to do your job, right? And
On a
so,
temporary basis. I mean,
right,
it can literally be 5 minutes that you had to sit out of a training protocol, or something. You had just a momentary spike in your blood pressure, or some abnormal EKG, or something that temporarily took you out of your normal work routine. That's
yeah,
all.
exactly. I mean, it could even be from full duty to light duty. I mean, you could go and
Right,
never miss any time from work, right? You could be, never miss 1 hour of pay,
right.
right? But you go from full duty, riding the back of a truck or being in a squad car, to, doing light duty in the office. And that is going to satisfy the element. But people file claims, and I talk to people all the time. They're like, oh no, my claim was denied because they said, I didn't miss a week of work. Well,
That's Apollo. This is the biggest thing that I know, and we've seen this for years now.
and
It's
and
just
the whole week, missing a week of work, I mean, that is technically in the statute, but that's to trigger your payment of lost wages.
the payment of lost wages, and it's really almost fraudulent to tell
It,
somebody. If
it
you're going to say that to somebody who has a Hart Bill claim, that you didn't miss a week of work, therefore you're not covered. That is technically fraud under the
Right.
statute.
And I mean, I have those conversations regularly. I'm
Well,
like, you don't have to miss a week of work. You don't even have to miss one day. If you went from full duty to light duty, or you missed 20 minutes, that's enough for disability. right? And then
Right.
we file that claim and then they roll over. But what happens is they get 100 claims. They tell 100 folks they don't meet the disability prong, and 80 of them
99 of them go away,
and
right?
99 of them go away, right?
Oh,
And so the one guy that calls us, ends up with a valid claim, but the other 99 end up missing out. So it's really important, right? And so, I mean, I think that's a good place to, to kind of wrap it up. I mean, this statute is a powerful law, right? But it's not automatic. Okay. You've got to know your rights. You've got to check your 4 boxes, and you've got to talk to somebody who understands how to play this game, because unfortunately the insurance companies are going to make a game out of your life.
oh, it is a game to them, 100%. It's a
Right.
game.
And at our firm, this is what we do. This is it. This is all we do. 100%. It's talk to, our men and women on the front lines who are having these conditions, getting their claims denied, having their careers ended early because of a bunch of insurance company nonsense. So before you file your claim, give us a call. The conversation is free. The information is free. If you've found any of this podcast useful, please feel free to like, share, tell a friend to watch. You can reach out to us on at our website, bicklerlaw.com. You can email us at info@bicklerlaw.com. You can follow us on Facebook and Instagram at bicklerlaw. And to sum up, we are so grateful for all of our first responders in this state. And if there's anything we can ever do to help you, please feel free to call and reach out. Stay safe, and thank you.
Thanks very much.
Thanks for listening to Shielded. At Bickler & Longo, this is what we do. We've represented thousands of first responders across the state of Florida. If you need assistance, don't wait. Please reach out. To learn more, head over to bicklerlaw.com or email us at info@bicklerlaw.com. You can also follow us on Facebook and Instagram at Bickler Law. And if you found today's episode to be helpful, please share it with a fellow first responder who might need to hear it. Until next time, stay safe, and thank you for all you do.